Uh, Thank you. There's a program, this is a program by Lucy's Children. You know, we periodically put on what we'd like to think are page-turning events, get people to thinking, get people to consider other perspectives, and basically to talk about things that are not every day. And in that regard, I invited my internet cohort friend, Alan, to join us tonight. Alan and I met each other through Daily Kos, which some of you may be aware of, which does progressive commentary and newsworthy information across the country. And I liked Alan's thinking. I liked the fact that he was a progressive, that he was very well educated, and I say that from an outside doctoral position, and I appreciated his candor. And I thought that given our situation in American politics today, that we could take a good brushing, a thorough sort of shaking out of the American rug and see what at least Alan has to say about it. Before I bring him on board, and I'm not going to give you his litany because you can read that on your own. You're all very literate people. Lucy was an Australopithecus who was found in 74 by Dr. Johansen on a ride back from an earlier dig back to the camp. And one of his graduate students said to him, "I see something interesting over there in the dirt." You know, anthropologists live in the dirt. And it turned out it was a shoulder. And it happened to be a shoulder of something that was over 3 million years old, and opened the door for further discussions on the evolution of humans. And I guess with that and some other anthropological finds, we have, of course, located the fact that, you know, Africa was the mother of civilization. I don't even know why we're having that discussion or that argument, but the point of the matter, we are trying to progress from that point forward. Now, we are in a country that declared it was a democracy. All of us have different reads on whether it made it, didn't make it, could make it, all of that. And in that regard, I am going to invite Dr. Alan Singer to come forward and for him to give us his appraisal. Thank you.
One, first, I hope I don't disappoint. And second, I hope I don't leave you too depressed. I'm going to try to end upbeat on possibility so I can go home and keep going on. We're calling this 19th century American politics in the 21st century, because what I'm going to show is a lot of the oppressive policies that are being pursued are efforts really to rewrite and eliminate many of the advances that have taken place in the last 150 years. I don't like to yell fascist at something I disagree with. Fascism is one of those terms that describes too much and too little at the same time. It is usually associated with an authoritarian dictatorship, uncritical support of a supreme leader, extreme nationalism, ethnocentrism, racism, scapegoating, manipulation of the law, suppression of dissent, and threats to neighbors. In countries torn apart by traumatic events and conditions, fascist politicians and regimes, while anti-democratic, often have populist support. They may rhetorically denounce big capital, blame it for some of the nation's problems, but their sustained control over society rests on alliances with wealthy industrialists and financiers. We see a lot of these characteristics in Trump and MAGA today, though it's hard to attribute any thought ideology to the egotistical and erratic Trump and a movement riven by internal contradictions. That is one reason I don't like to call them fascists, but I'm really worried about what the future holds. On December 18, 1865, Congressman Thaddeus Stevens, the Republican from Pennsylvania. Now, if you remember the movie Lincoln, he was played by Tommy Lee Jones. That's the Tommy Lee Jones character in the Lincoln movie. Now, during debate on how to treat the traitorous Confederate states and on support for the newly freed people who had been enslaved in the United States and British North America for almost 250 years, Stevens warned, quote, "If we fail in this great duty now, when we have the power, we shall deserve and receive the excoriation of history and of all future ages." The United States failed to rectify injustice in the past and is failing once again. And I think it does deserve at this point the excoriation of his. It's a condemnation, though it really sounds like shit, doesn't it? Okay. Nicole Hannah-Jones, a key contributor to the New York Times award-winning 1619 Project, recently wrote that the civil rights era is collapsing before our eyes. In Tennessee, the white-dominated, Republican-controlled state legislature eliminated the state's only black majority congressional district after the MAGA-dominated Supreme Court ruled that congressional maps that ensured political representation for African Americans and other racial minorities somehow violated the Constitution. Other white-dominated Republican-controlled states are racing to make similar changes. It is as if the Republican Party, with the aid of the Supreme Court, is trying to return the United States to the level of racism that dominated the country in the 19th and first half of the 20th century. And there's just a lot of things that are troubling right now. Income inequality in the United States has risen steadily for at least the last 50 years, and it is at its highest level since the 1890s Gilded Age. The top 1% of earners hold a share of national income that rivals the peak share that they had in pre-Depression 1920s. They receive almost 1/4, with over 10% of the income going to the 0.1% and 5% of the income going to the 0.01%. So we live in a society that's increasingly top-heavy, and a society where the wealthy have extraordinary economic and political power. We know Elon Musk is now our first trillionaire. The 6 right-wing judges on the Supreme Court just took the United States one step closer to fascism by overturning congressional legislation and a 90-year-old legal precedent that prevented presidents from removing independent regulators without cause because they were members of the opposition party, because they did not agree with questionable directives. With the court's decision to broaden presidential elected power, Trump can remove any expert who stands in his way by defending vaccinations, protecting the environment, or addressing climate change. For almost 150 years, through civil service reform and the creation of independent agencies by Congress, attempts were made to keep politics and personal peeve out of the functioning of government agencies. Supreme Court has now empowered Trump to get rid of it. In a lengthy response to the court majority, Justice Sonia Sotomayor, I think she's from the Bronx, charged independent agencies will, quote, be transformed in ways that those who created them could never have expected and actively sought to avoid, fundamentally recalibrating the balance of power in this country in the process. The court gave Trump power that neither the people nor Congress nor the Constitution bestowed upon him. In granting the president its unbridled authority, the court upends its precedent, misconstrues our history, and sheds any pretense of judicial modesty. Just as an aside, the 6 right-wing justices on the court, each in their congressional hearing, pledged to support legal precedents, which means every one of them lied to Congress while under oath. They should be impeached and imprisoned. But they did it. Let's see what happens. Now, in January 2025, President Trump issued an executive order to strip away citizenship from children born in the United States to parents without legal status or in the country on a temporary basis. A class action lawsuit, Barbara versus Trump, brought by the ACLU and a number of civil rights and legal groups, effectively blocked implementation of the executive order while the case wended its way through the courts. Trump's executive order would have denied citizenship to U.S. soccer striker Folarin Balogun, who was born in the United States while his parents were visiting from Great Britain. His mother was pregnant. She went into labor. They wouldn't let her on the plane to go home. But I don't even know what Trump pays attention to. Many of us breathed a deep sigh of relief that in a 6-3 decision, the United States Supreme Court upheld the constitutional provision in the 14th Amendment ensuring citizenship to all children born in the United States, except for the rare cases when their parents are diplomats representing other countries. This includes children of immigrants, whether they are documented or not, and children whose parents are in the United States only temporarily. As Chief Justice John Roberts and Associate Justices Amy Coney Barrett, Ketanji Brown Jackson, Sotomayor, and Elena Kagan asserted in support of the majority of the decision, the Constitution says what it says. That's what it says. However, frighteningly, 4 of the Supreme Court justices issued opinions that ignored what the Constitution plainly says. Brett Kavanaugh voted with the majority, but not because the Trump executive order violated the 14th Amendment, but because it contradicted a 1940 federal law. Kavanaugh's position left room for Congress or the court to overturn birthright citizenship in the future. Samuel Alito and Neil Gorsuch invented their own new standard for citizenship, claiming that a child's parents had to be, quote, domiciled in the United States or a permanent resident. The fact that the term domicile does not appear in the 14th Amendment or in later legislation or anywhere in the Constitution did not bother them as they try to rewrite the meaning of the Constitution to suit their biases. Clarence Thomas, who was excoriated by Jackson for hypocrisy, tried to limit birthright citizenship to the formerly enslaved and their children, although that is also not what the Constitution says. A recently released memo shows that in the spring of 2025, Donald Trump and Deputy Chief of Staff Stephen Miller, I have to spit over my shoulder, Stephen Miller, proposed suspending habeas corpus in the United States by executive action, an idea that was later dropped. The plan was to target undocumented immigrants, but once it was suspended, habeas corpus was suspended, anybody could be targeted. Now, habeas corpus is enshrined in the United States Constitution to ensure that the accused have judicial recourse. In the past, habeas corpus has only been suspended 6 times. Once in New Orleans during the War of 1812, twice during the Civil War, once to combat Klan terrorism in South Carolina during Reconstruction, once to suppress a rebellion in the Philippines colony, and the last time in Hawaii immediately following the attack on Pearl Harbor. It has never been used other than those extreme cases. Now, President Trump has a new weapon in his long hostility to journalists, who he often attacks as treasonous enemies of the people. The Trump administration had Don Lemon, Georgia Ford, and John Bowman arrested and charged them with disrupting a religious service at the city's church in St. Paul, Minnesota. Lemon has a show on YouTube. Ford and the photographer Bowman are independent journalists. In addition to the 3 journalists, dozens of protesters are charged with conspiring to violate the rights of the parishioners to religious freedom. In their defense, Lemon, Ford, and Bowman claimed that they were in the church covering the anti-ICE protests as journalists. They were not there as protesters. The Trump Justice Department does not acknowledge that the First Amendment offers any relevant protection to the accused, because they claim journalists are not above the law. They want to limit freedom of the press, so it only covers publication of the product, but not the investigation of wrongdoing. So if you're involved in investigating wrongdoing, you can go to jail. After the Civil War, Congress passed and the states ratified the 13th, 14th, and 15th Reconstruction Amendments to the United States Constitution. 13th Amendment ended chattel slavery in the United States. The 14th Amendment defined citizenship to include people born in the United States, again with very limited exceptions. The 15th Amendment prevented states and localities from denying black men the right to vote. Women, didn't get the right to vote until 1920. Each amendment included a clause that, quote, Congress shall have the power to enforce by appropriate legislation the provisions of this article. That's in the Constitution. Rebelling Confederate states were required to approve the 14th, 15th Amendments to fully re-enter the Union. The right-wing dominated Supreme Court at the time then systematically emasculated the amendments and supporting legislation, including civil rights acts. They overthrew an enforcement act which provided federal protection for voting rights that were being interfered with by organizations like the Ku Klux Klan. The Civil Rights Act of 1875 targeted racial segregation and guaranteed African Americans equal treatment in public accommodations, including hotels and theaters and transportation, and prohibited attempts to exclude them from juries. This was all done to put enforcement against the violations that were being done. However, starting in 1873, the Supreme Court began to limit the ability of African Americans to secure their rights. First, they took away their right to sue in federal court. Then they said the 14th Amendment did not apply to private acts of violence, preventing federal authorities from prosecuting hate crimes like conducted by the Klan. And then in 1883, the court threw out the Enforcement Act altogether because Congress didn't have the power to punish private groups like the Klan for conspiring to violate civil rights of African Americans. The most damaging court decision was in a consolidated case known as the Civil Rights Cases. In 1883, by an 8-1 majority, the Supreme Court declared the Civil Rights Act of 1875 unconstitutional. So all of these provisions that the Constitution said Congress could do to ensure the rights of the 13th, 14th Amendment, 15th Amendment, the right-wing Supreme Court in the 1870s and 80s just threw them all out. The majority ruled that the 14th Amendment only applied to discrimination by state or local governments and did not permit the federal government to prohibit discrimination by private individuals. The only dissenting justice was John Harlan, who argued that government and individual actions often overlapped, and the court was interpreting the 14th Amendment too narrowly. Harlan was also the only justice to vote against the majority decision in Plessy versus Ferguson in 1896 that established that the Constitution permitted racially segregated, quote, separate but equal facilities. It was not until the 1950s and 1960s, and what has been called the Second Reconstruction, that the Supreme Court decisions and federal legislation, under intense pressure from the African American civil rights movement, restored civil rights for African Americans that had been stolen by a conservative Supreme Court in the 1870s, 1880s, and 1890s. The best known Supreme Court decision was Brown versus the Board of Education, combined 5 cases challenging the legality of school segregation. In an unanimous decision, the Supreme Court, under the leadership of Chief Justice Earl Warren, ruled that segregated schools established a racial caste system and violated the Equal Protection Clause of the 14th Amendment. In other decisions, the Warren Court ruled that Mexican Americans and other racial groups had equal protection under the 14th Amendment, that segregated facilities serving in interstate transport were illegal, that election districts intended to prevent the election of black representatives violated the 15th Amendment. They ruled against segregation in public accommodations. They said the federal government had the authority to abolish discriminatory voter registration requirements. They said that states could not ban interracial marriage, and the Fair Housing Act banned discrimination in the sale and rent of housing, unless you were a developer like Trump. Federal legislation passed in the Second Reconstruction included a series of civil rights acts to ensure that the Supreme Court decisions and the 14th and 15th Amendments were followed. The 2 most important pieces of federal legislation during this period were the Civil Rights Act of 1964 and the Voting Rights Act of 1965. The Civil Rights Act outlawed segregation in public accommodations, including hotels, restaurants, and theaters. It ended discrimination in employment based on race, color, religion, sex, or national origin, and created the Equal Employment Opportunity Commission to enforce regulations. Well, Trump now has the ability to fire all of them. Title VII of the Civil Rights Act is very important. It established a legal principle called disparate impact. And under the disparate impact legal standard, which was upheld by the Supreme Court, it prohibits policies that disproportionately impact on protected groups. It does not require proof of discriminatory intent, and it was later codified in the Civil Rights Act of 1991. If a government action has discriminatory impact, it is illegal, both under the Civil Rights Act of 1991 and under the Supreme Court decision in Griggs versus Duke Power, and under the disparate impact provision of the 1964 Civil Rights Act. Basically, everything that Trump has done is illegal. Now, that's their strategy. They just do shit, and they say, take me to court. And it goes on, and now we have a court that's allowed them to get away with it. The Voting Rights Act included a number of key provisions. It allows people to sue to overturn discriminatory laws and voter registration and candidate nomination procedures, and provided for federal legal assistance. It also required states and localities with histories of discrimination to obtain prior approval from the Justice Department or federal court before changing voting rules. As a result of the Voting Rights Act, the racial disparity in voter registration rates declined from about 30% to 8% over the course of 10 years. As a result of the Voting Rights Act, the number of blacks serving in Congress increased from 4 in 1960 to 62 in 2023. 2006, the Voting Rights Act was reauthorized by Congress with bipartisan support because it had such a powerful impact. However, since 2013, the Supreme Court has whittled away at voter protection for minority groups. In Shelby County versus Holder, the court eliminated the pre-clearance requirement of the Voting Rights Act. Racism is gone. We don't need it anymore. In 2021, the Supreme Court made it more difficult to bring lawsuits challenging discriminatory rules. And in 2026, in Louisiana versus Calais, the court further gutted the Voting Rights Act, allowing state governments to redraw election districts, dividing up black communities so it would be almost impossible to elect black officials. Now, what the court said was, well, if they did it for partisan reasons, that's not racist. But according to the disparate impact law, if it has a disparate impact, then it is racist. The court ignored the law. I don't know if they can't read or if they just overwhelmingly biased. See, I can't be a Supreme Court justice. It's not because I'm not a lawyer. There's no lawyer requirement. It's just because I'm an ideologue. But looking at it, so are they. They don't belong on the court. As far as I could see, there are the people they call liberal. They're conscientious legal specialists. They're not radicals. You know, Paul Douglas in the 30s, Thurgood Marshall in the 60s, they were radical. These are just conscientious legal minds. The others vote on their biases. Now, the Trump administration has lost a systematic campaign to undermine the civil rights protections passed into law and proved by the Supreme Court in the 1950s and 60s. In an attack on the Civil Rights Act of 1964, Trump issued an executive order in April 2025 ordering federal agencies not to support or enforce the disparate impact claims, arguing it was discrimination against white people and violated the Trump interpretation of equal protection laws. The Trump administration has cut funding for enforcement of fair housing laws, equal employment opportunities, environmental justice for minority communities that are disproportionately impacted by climate change and pollution. It is just, if it can't overturn the law, it just defunded enforcement. With the Supreme Court rulings against the Voting Rights Act and the Trump administration's refusal to support the Civil Rights Act, they are trying to repeal the legacy of the Second Reconstruction and return the United States to the era of Jim Crow segregation and racism institutionalized in the 19th century. German pastor Martin Niemöller is remembered for writing about the rise of Nazism in Germany. And he writes, "First they came for the socialists, and I did not speak out, I wasn't a socialist. Then they came for the trade unionists, and I did not speak out, I wasn't a trade unionist. Then they came for the Jews, and I didn't speak out, I wasn't a Jew. Then they came for me, and there was no one left to speak for me." And we have to remember that, because if we don't speak when they take our neighbor, the next one they take is going to be us. We cannot afford to wait. It was activist abolitionists who who brought about an end to slavery in the United States, and the African American civil rights movement that produced the Second Reconstruction and led eventually to liberation for women, for gays, for people with disabilities, and immigrant workers. I want to close with an excerpt from a speech by the African American abolitionist Henry Highland Garnett that he delivered in 1843. And when I was a high school teacher, now as a teacher educator, we use this speech. So really to see how Lincoln didn't free the slaves. It was a movement of people, including black and white, who fought against this injustice. So this is what Henry Highland Garnett said in his speech. Brethren, it is wrong for your lordly oppressors to keep you in slavery, as it was for the man-thief to steal our ancestors from the coast of Africa. You should therefore now use the same manner of resistance that would have been just in our ancestors when the bloody footprints of the first remorseless soul thief was placed upon the shores of our fatherland. The humblest peasant is as free in the sight of God as the proudest monarch. Liberty is a spirit sent out from God and is no respecter of persons. Brethren, arise, arise, strike for your lives and liberties. Now is the day and the hour. Let every slave throughout the land do this, and the days of slavery are numbered. You cannot be more oppressed than you have been. You cannot suffer greater cruelties than you have already. Rather die freemen than live to be slaves. Remember that you are 4 million. Let your motto be resistance, resistance, resistance. No oppressed people have ever secured the liberty without resistance. Trust in living God, labor for the peace of the human race, and remember that you are 4 million. I think we know about 80 million. Thank you very much.